Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about an issue that I've talked about a lot. I feel rather passionate about it. I will point out that most of you clearly do not. Every time I do a video on this topic, it gets about 6 views, so not really sure why I'm doing it, but here we go. But it has to do with legal cannabis users and their inability to defend their own life through their Second Amendment rights. Because as you know, there is a federal prohibition that even if you're an occasional user of cannabis, you are not to be in possession of a firearm. Well, that has split a lot of courts, and there's been a lot of great debate as to whether or not that law is constitutional. And as we're having this great awakening experience in the post-Bruin world, this is one of the many areas that we're kind of tending to re-examine. Well, it appears that the Fifth Circuit has come up with a pretty clear answer, and for those of you who may use cannabis, you're going to like the answer here. So today, let's spend a few minutes, let's go through the order, let's geek out and talk about the huge ruling which could strike down a major federal gun law. Okay, America, the case we're talking about today is United States versus Paola Connelly. Now, the name is Paola Connelly. For whatever reason, the court refers to the Paola name as if it is the last name. I don't know whether that's the case or not. So as you see this name being used throughout the quotes, you're going to understand I'm just cutting and pasting directly from the court's opinion. This is a case that comes out of a 3-judge panel in the Fifth Circuit. It is a challenge to 18 United States Code Section 922, Section G3, which is the prohibition on cannabis users actually even being able to possess firearms, and as well as a challenge to Section 922 D3, which is the prohibition on transferring firearms to individuals that you know to be a known controlled substance user. At the lower court, Paola here actually prevailed on both a facial challenge and an as-applied challenge to both laws, okay? The court here, however, has actually overturned a big chunk of that ruling, and yet Paola is still going to win, because as the court has ruled, we affirm as to Paola's as-applied challenge and reverse as to her facial challenges. And so the victory may not be as big as it once was, but for Paola Connelly, the results will be the same, that this law cannot be enforced against her because it is unconstitutional. The facts of this case really are not dissimilar to a lot of other cases we've talked about. Ms. Connelly was found to be in possession of a firearm and also admitted to law enforcement that she was an occasional user of cannabis to help with anxiety as well as sleep. Now, one of the big reasons that perhaps we are passionate about this issue here at Washington Gun Law, well, is number one, we are in a state that has legalized cannabis. And even though this state has a lot of problems and we are falling apart for many reasons, our legalized cannabis industry is not creating those problems. But perhaps the bigger reason is that as a defense attorney, I have dealt with a lot of people who have dealt with a lot of issues, both physical issues as well as psychiatric issues. And I have seen medicinal cannabis used in pain management and the management of certain mental health issues. And one of the biggest groups of individuals that I see benefits coming from is in the treatment of our veterans. So I find it to be very offensive that we would want to treat our veterans with this substance, which oftentimes is exactly the right medical call to make, and yet then tell them that they need to be disarmed. And so that is one of the big reasons why we really support what the kind of rulings that come out of the Fifth Circuit. Now, as we know, anytime we're going to take a look at the constitutionality of some type of gun control legislation, we're going to have to run it through the Bruin test. And of course, the first question is going to be, does the plain text of the Second Amendment cover this activity? And the great escape hatch for government, especially if they know they got no history on the back end to back them up here, is to try to argue that, hey, judge, the Second Amendment's not even in play. This individual, yeah, see, she's a pot smoker. And because she's a pot smoker, she ain't part of the people. And of course, that is exactly the argument that the United States government made. The Fifth Circuit, and this is important, the Fifth Circuit reasoned it this way. Based on the consistent usage, Heller concluded that the Second Amendment right is exercised individually and belongs to all Americans. Marijuana user or not, Paola is a member of our political community and thus has a presumptive right to bear arms. By infringing on that right, Section 922 G3 contradicts the Second Amendment's plain text. So we move to the second step, whether history and tradition support Section 922 G3 as applied to Paola. Okay, That is a huge ruling because now we are through the threshold to where the government's going to have to step up and justify this with historical analogs. And we know what the problem the government is going to have there. Now, of course, we always give the government A for effort because this is one of the most creative parts we ever see in government briefing. They have come up with 3 reasons why there is historical analogs that would support this ban. They include 1, laws disarming the mentally ill. 2, laws disarming dangerous individual, and 3, intoxication laws. And the court considered and then rejected each and every one of those. Now, let's just start right from the very top. Laws that disarm those that were mentally ill. Okay, I think we can all agree that that's a stretch. A person who is chronically mentally ill is quite different than the occasional cannabis user. And as the court correctly finds here, but the laws designed to disarm the severely mentally ill do not justify depriving those of sound mind of their Second Amendment rights. The analogy stands only if someone is so intoxicated as to be in a state comparable to lunacy. Just as there is no historical justification for disarming citizens of sound mind, there is no historical justification for disarming a sober citizen not presently under an impairing influence. The court went on and further found, while intoxicated, she may be comparable to a severely mentally ill person whom the founders would disarm, but while sober, she is like a repeat alcohol user between periods of intoxication whom the founders would not disarm. And that has always been one of our big beefs. I completely understand any law that disarms any individual who at that moment is under the influence of a substance. But to suggest that occasionally being under the influence of that substance means that you are permanently deprived of that right, there is absolutely 1, no historical analog, and 2, no reasonable or common sense nexus to do that. Next, of course, is the laws that disarm those that were dangerous. And we go and we take a look at the British loyalists and those darn Catholics and the Irish and the Native Americans and the enslaved and all the other people who really had reasons to be pretty ticked off. And as the court said, yeah, there may have been a historical precedent of disarming these people, but if you go and you take a look at the underlying reason for all of it, it's all political in nature, okay? These people were highly likely to create violent outbursts because of the politics involved in it. Here you're talking about a pothead, okay? And as the court basically points out, so we must ask, why were the groups disarmed at the founding considered to be dangerous and therefore disarmed? And is that why relevantly similar to 922 G3? It is not. The government identifies no class of persons at the founding who were dangerous for reasons comparable to marijuana users. Marijuana users are not a class of political traitors, as English loyalists were perceived to be, nor are they like Catholics and other religious dissenters who were seen as potential insurrectionists. I grew up Catholic. I never once thought I would read a legal brief where the Catholics were being compared to the marijuana users. But hey, you learn something new every day. And then, of course, the final one is that they argue, and this is at least somewhat in the ballpark. Well, it's not really in the ballpark. It's kind of like in the parking lot, sort of next to the ballpark here, which is the laws that ban possession of firearms while you are presently under the influence of something. And as the court very correctly points out, why this is also not persuasive, as applied to Paola, Section 922 G3 restricts her rights more than would any of the historical and traditional laws highlighted by the government. While older laws' bans on carry may be analogous to Section 922 G3's ban on possession, there is a substantial difference between an actively intoxicated person and an unlawful user under Section 922 G3. And of course, if we adopted the government's position, well, then wouldn't this also become true? Indeed, under the government's reasoning, Congress could, if it wanted to, ban gun possession by anyone who has multiple alcoholic drinks a week from possessing guns based on the intoxicated carry laws. Okay, and then we said at the very beginning that the facial challenge to these laws was actually overturned, but the as-applied challenge was upheld. What's the difference? A facial challenge is a very lofty burden, okay? The plaintiff in that situation is going to have to show that under no circumstance imaginable would this law ever be constitutionally applied, okay? There is literally no imaginable scenario in which there would be a true constitutionally correct application of this law. But as the court pointed out, hey, listen, these laws would ban the possession of a firearm by a person who was actually under the influence of a controlled substance, and this law would also ban the transfer of a firearm to a person who is obviously under the influence of a controlled substance, and that would still be illegal, and the enforcement of this law would not be unlawful in that situation. And for that reason, the facial challenges are actually struck down. They are overturned. However, there was an applied challenge, and an as applied challenge is exactly as it says, which is when we take a look at the application of the law to this set of facts, this limited set of facts as it relates to this named defendant, yes, this is unconstitutional in its application, and therefore the law cannot be enforced. Ultimately, the court makes the following ruling. Paola's Section 922G3 charge is inconsistent with our history and tradition of firearms regulations, and for the reasons discussed above, so we affirm the judgment of dismissal as to her as-applied challenge. But the holding is narrow. There undoubtedly exist circumstances where Section 922G3 may apply constitutionally, such as when it bans a presently intoxicated person from carrying firearms. So we reverse as to Paola's facial challenge. Listen, this is a huge, huge ruling, and with the Daniels case now being GVR'd back down to its court of origin from the United States Supreme Court post-Rahimi, it's going to be very, very interesting to see how this issue percolates and whether or not it puts itself in a position where it would be ripe for review by the United States Supreme Court. The case, once again, is United States of America versus Paola Connelly. We're going to go ahead and link up the order of the court down below so that you guys can geek out on it for yourself. Maybe you got questions about this or something else related to what's left of our Second Amendment rights. If you guys want to get a hold of Washington gun law, all of our contact information is down there in the description box. Maybe you just got an idea for a video. If you do, tell us about it by clicking on that link right there. Most of the good ideas we come up with, actually we don't come up with at all. Maybe you just want to be part of our monthly newsletter. The ability to do that and subscribe is all down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.